All right, future barristers, listen up. We're about to tackle a case that is, and I mean this, one of the most important civil procedure cases you will ever study. Seriously, getting this one wrong in practice, well, it's going to land you in a world of trouble.
So, here's how we're going to break this down. First, we need to understand what the world looked like before this case dropped. Then, we'll walk through the decision itself, step by step. And we'll wrap up with the really critical takeaways for you as a future practitioner.
Okay, so before 2009, things were, let's just say, very different when it came to late amendments. The whole scene was dominated by this one powerful idea from a case called JL Holdings. And what was that idea? Well, it was a world where, if you messed up, you could pretty much just buy your way out of it.
And this slide, wow, it just perfectly nails the huge philosophical shift we're talking about. Look at the left, the old way, JL Holdings. Justice is the paramount consideration. Simple, right? Full stop. Now look at the right, the new world of Aon. Justice is all about minimum delay and expense. It's not a small tweak. We're talking about a fundamental change in the very DNA of our justice system. And for more than 100 years, this was the thinking. This quote you see here from Bowen LJ, it was the absolute bedrock of the old approach. You messed up your pleading, you caused a delay, hey, no problem. As long as you put your hand in your pocket and offer to pay the other side's costs, the courts would pretty much always let you amend your case. Costs were seen as this great equalizer, this panacea, right? The cure for all your procedural sins.
So, you have to ask, what could possibly shake a rule that's been around for over a century? Well, it took a perfect storm, the absolute perfect storm of circumstances. And that storm came in the form of the adjourn versus ANU case.
Now, the facts here are pretty straightforward, but the timing is everything. So you've got this catastrophic fire. ANU sues its insurers, and they also sue their broker, Aon. The whole thing is set down for a big 4-week trial. But then, get this, on day 3 of the trial, ANU settles with the insurers. And in the same breath, they try to completely change their entire case against Aon. I mean, the crucial point here is the timing. To try and fundamentally change your case on the 3rd day of a month-long trial, that is an audacious, high-stakes, system-disrupting move.
So this lands right in the High Court's lap, and they're faced with this massive question. In our modern legal system, where court time is so precious and delays screw up everything for everyone, is it really still enough to just say, hey, I have an arguable case, and here's a check for your costs? Was that old panacea from Bowen LJ still the right medicine for the 21st century?
And the court's answer? It was a resounding no. Absolutely not. And in saying no, they laid down a completely new doctrine for every court in Australia, essentially blowing up the old permissive approach from JL Holdings.
And this quote from Chief Justice French, it's from paragraph 5 of the judgment, it gets right to the heart of this new way of thinking. Let's really pull this apart, because he's making 2 massive points. First, he says delay causes real, unfair prejudice that you can't just fix by throwing money at it. But the second point, this is the real game changer. The court's time isn't some private playground for the litigants. It is a publicly funded resource. That means when you waste it, you're not just hurting your opponent, you're actually damaging the entire justice system. You're eroding public confidence in how we do things.
Then you have the joint judgment, this is in paragraphs 92 to 103, and they just build on that foundation. They make it crystal clear. Case management, it's not just ticking boxes. No, it's central to achieving justice. And justice itself isn't a private fight anymore. It's about the impact on the court and on every other person waiting in line for their day in court. And here's the kicker for you. You have no right to an amendment. It's an indulgence the court might grant you. And if you want it, you had better come with a full, frank, and very, very good explanation for why you're so late to the party.
And really, this is the absolute core of the entire decision. A just resolution doesn't just mean a fair fight between 2 people anymore. Think of it like a 3-legged stool. You've got fairness, efficiency, and the public interest. They are now completely woven together. You can't separate them. If one leg is missing, the whole thing falls over.
Okay, so if the old magic pill of costs isn't the answer anymore, what does that actually mean for you on the ground as a practitioner? Well, it means you absolutely cannot assume that offering to pay costs is going to be your get-out-of-jail-free card anymore.
And the court tackles this head-on right there in paragraph 99. They directly confront that old thinking. They recognize that the real-world damage from delay, it goes way beyond just the money. Think about it. It's the stress on your witnesses. It's the wasted time of executives who should be running a business. It's a company diverting all its resources away from what it's supposed to be doing. It's just that awful anxiety of having litigation hanging over your head.
An order for indemnity costs, that's not going to fix any of that.
This chart really puts it all into perspective, doesn't it? The financial bit, the part a costs order can actually fix, that's just the tip of the iceberg. It's what you see above the water. But underneath, that's where the real damage is. The unrecoverable prejudice to your opponent, the massive cost to the justice system itself, those are the huge, hidden burdens that the High Court is now saying we all have to care about.
So this is your practical nuts and bolts takeaway. Before you even think about filing an application to amend, you have to run through this mental checklist. Number 1, where are we in the proceedings? How late is this? Number 2, my explanation for the delay, is it rock solid? Is it full and frank? 3, can the damage to the other side really be fixed with money? Be honest. And 4, what's the impact on the court and other litigants? Because I promise you, the court is going to be asking these exact questions, and you need to have fantastic answers ready to go.
But we're not done, because the final word, and honestly the most memorable lesson from this entire case, comes from the separate judgment of Justice Hayden. And let me tell you, it is absolutely scathing. See, he didn't just look at this case and see one mistake by one set of lawyers. No, he saw a systemic failure. He saw a culture of delay and procrastination that had been allowed to fester for years. And he clearly decided that the High Court was the place where it had to stop, right here, right now.
And that brings us to this absolutely unforgettable line from paragraph 156. It's the ultimate warning against being lazy with procedure. What's he saying? He's describing this awful cycle where one side is sluggish and the other side and even the court is just as slow to react. The torpid languor of one hand washes the drowsy procrastination of the other. It's brilliant. And that quote, right there, has become the lasting legacy of this case. It's this powerful, poetic smackdown of inefficiency in our justice system.
And so that is the crucial question that Aon versus ANU lives for you and for every single litigator in Australia. How are you going to make sure your practice avoids this torpid languor? Because the days of relaxed, slow-motion litigation, they are long gone. Justice isn't just about getting to the right answer anymore. It's about how you get there. And that journey has to be efficient, it has to be focused, and it has to respect the public resources it's built on.